Today, I want to share with you the important points residential landlords need to know about the nationwide CDC residential eviction moratorium issued to prevent the further spread of COVID-19. I hope you and yours are doing well. If you've heard about the CDC residential eviction moratorium order, but are unsure how the order affects landlords and tenants and have questions about what tenants must do to be covered by the order, I'm going to answer those questions in this video. So the order temporarily halts residential evictions of covered tenants for non-payment of rent, and it went into effect on September 4, 2020 and will remain in effect until December 31, 2020. The order applies to any property leased for residential purposes. What does that include? Well, it includes any house, building, mobile home, or land in a mobile home park or similar dwelling leased for residential purposes. On the other hand, it does not apply to hotel rooms, motel rooms, or guest houses rented to temporary guests or seasonal tenants. But not so fast. The moratorium does not apply to residential tenants automatically. Tenants have to opt in to be covered. Only by submitting a sworn declaration to their landlords can tenants become covered. That declaration must state the following. 1. The tenant has used best efforts to obtain all government rent assistance. 2. The tenant expects to make less than $99,000 in 2020 or no more than $198,000 if filing a joint return. 3. The tenant is unable to pay full rent due to substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. 4. The tenant is using best efforts to make timely partial payments. 5. Eviction would likely render the tenant homeless or force the individual to move into close quarters in a new shared living setting because the individual has no other available housing options. On top of that, tenants who've submitted declarations to their landlords must still fulfill their obligations to pay rent and follow the terms of their lease. Covered tenants owe their landlords any fees, penalties, or interest provided for in the lease resulting from their failure to timely pay rent during the moratorium. The moratorium does not prevent landlords from starting eviction proceedings during the moratorium, provided that the actual eviction of a covered tenant for non-payment of rent does not take place during the moratorium. Lastly, this order provides significant penalties for violation of the order. A person who violates the order may be subject to a fine of up to $100,000 or 1 year in jail or both. An organization violating the order may be subject to a fine of up to $200,000 per event. Additionally, anyone who falsely claims to be a covered tenant under the order by attesting to any material information which they do not believe to be true may be subject to criminal penalties for perjury. So what's the takeaway? You need to be informed of the requirements of this order so you will have a plan to deal with non-paying tenants. Let us know what topics you're interested in hearing about next in the comments. We release videos like these on Mondays, and if you found this informative, please hit like. Check out our other social media pages at the Thomerson Law Firm for more relevant content. Stay safe and stay in the know. See you next Monday.